Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. South Carolina, you did it. You passed constitutional carry, sort of. And what I mean by sort of is that, listen, you guys couldn't get out of your own way this legislative session. This process was way more gut-wrenching than it probably needed to be. And because of that, this is not a really clean bill that's going to make it to the governor's desk. Now, I know those that were out there were fighting like holy hell, and I appreciate all the efforts. Hey, I don't live in South Carolina. I wish I did, because you guys are all still doing way better than all of us out here in the People's Republic of Washington. But let's celebrate, but let's do with a couple of caveats, because there's some things you guys need to be aware of about this bill. So today, let's geek out on it, and let's talk about South Carolina finally passes constitutional carry. Sort of. Okay, South Carolina, today is the day, Wednesday, March 6th. Your state legislature has passed H.3 594, the final version of the South Carolina constitutional carry bill. It was a long and arduous process, by far the most gut-wrenching move towards constitutional carry that we've ever seen on this channel, and candidly ever seen anywhere in the United States. This thing was a little bit more difficult than it needed to be, and that's what happens when your House and your Senate are not on the same page, not even in the same book in some senses. And because of that, because of this, South Carolina, this bill has a couple of things in here that makes you go, wow, is that really a true constitutional carry bill? Now, we're going to talk about all of that, but just so you understand, South Carolina, if you take a look at any of your firearm legislation, anywhere in the books, anytime it talks about a person carrying a firearm, pursuant to what was South Carolina's concealed carry statute, this bill eliminates all of that and just says that you are lawfully carrying a firearm at the time. Because we know under constitutional carry, you do not need government's permission to possess and carry a firearm. You don't need their permission to open carry it. You don't need their permission to conceal carry it. What you do need to be is an otherwise lawful, responsible gun owner. That is, so long as under both federal and state law, you are lawfully allowed to possess that firearm. You can carry it consistent with any restrictions that state law may put on the right to carry. Now, South Carolina, there's a couple of things in the bill I want to get you up to speed on, then we're going to talk about the real big concern. Your prohibited areas, sensitive areas, gun-free zones, whatever you want to call it in South Carolina, they have reworded the statute. I'm not certain if there have been any changes. I think there has been a couple additions, but I want you to understand that whether you're carrying with a concealed carry license or you're constitutionally carrying, under this legislation, as soon as it's signed by the governor, you will not be allowed to carry a firearm into any of these locations. 1, law enforcement, correctional, or detention facility. 2, courthouses, courtrooms, or other publicly owned buildings. 3, polling places on election days. 4, office or business meetings of the governing body of a county, public school district, municipality, or special purpose district. 5, schools or college athletic events not related to firearms. 6, daycare facility or preschool facilities. 7, places where the carrying of firearms is prohibited by federal law. 8, churches or other established religious sanctuary unless express permission is given by the appropriate church official or governing body. 9, hospitals, medical clinics, doctor's office, or any other facility where the medical services or procedures are performed unless expressly authorized by the appropriate entity. 10, residence or dwelling place of another person without the express permission of the owner or person in legal control or possession of the residence or dwelling place as appropriate. Or 11, any place clearly marked with a sign prohibiting a carrying of a concealable weapon on the premises in compliance with Section 23-31-235. And a person will be found in violation of that section of law, whether the violation is willful or not. So please be aware of some of these carrying restrictions. Couple other quick things. If you do have a South Carolina concealed carry permit and you lose it, you have to report that within 48 hours. And then if you have a firearm which is lost or stolen, you must report that to the appropriate local police authority within 10 days of the loss, the theft, or learning of the loss or theft. But South Carolina, this is what makes this far from a clean bill. Because when we look at Section 9 of this new legislation, we see the following. The availability of a permit to carry a concealable weapon under this section must not be construed to prohibit the permitless transport or carrying of a firearm in a vehicle or on or about one's person, whether openly or concealed, loaded or unloaded, in a manner not prohibited by law. Well, seems like South Carolina saying, hey, listen, whether you got a concealed carry license or you're just constitutionally carrying, the law will apply equally to you, okay? Except, well, that's not the case, you see, because now we have to turn to Section 22 of this bill. Because there is a provision that if you are carrying a concealed license and you use it in what you believe to be self-defense, but ultimately the prosecuting authorities believe to be the commission of a crime, and then they charge you with the crime, and then you are convicted of that crime, guess what? If you're carrying with a concealed license, you're going to be treated one way. If you're constitutionally carrying, they actually get to add more jail time. Don't believe me, South Carolina, this is how your new law works. A person convicted of committing or attempting to commit a crime involving a concealable weapon, as defined by Section 23-31-210 sub 5, in violation of an offense listed in Chapter 23, Title 16, or a violation of Section 10-11-320, must be imprisoned not to exceed 3 years. A term of imprisonment imposed for violating this section must be served consecutively to any term of imprisonment imposed for the underlying offense and may not exceed the actual sentence imposed for the underlying offense. So you get that? If you use a concealable weapon in the commission of a crime, they can add additional jail time automatically added on to the back end of the sentence if you're convicted of the underlying offense. But check out what the next part of that section says. This section does not apply to a person with a valid permit to carry a concealable weapon issued pursuant to Article 4, Chapter 31, Title 23, provided that the permit was valid at the time the crime was committed. So South Carolina, you now have a constitutional carry bill, which is heading to your governor's desk, that says that if a concealed carry individual uses a firearm in what they believe to be self-defense, but obviously later the prosecuting authorities and a jury later finds that no, it was actually criminal in nature, we get to drop a ton more jail time on an individual if they were constitutionally carrying, but the statute absolutely forbids us from doing that from a person who was carrying via a state permit. Okay, so South Carolina, have you done yourself good here? Yeah, you did yourself pretty good. Is this a constitutional carry bill? Yes, for the most part it is. But to be a true constitutional carry bill, every South Carolina citizen should be treated by the law exactly the same way. It's my hopes that your legislature will get back in there, clean this thing up, and you'll have a perfectly good piece of legislation at the end of next legislative session. North Carolina, you're now on the clock because you're about it. You're about the only state that really has a chance of this happening that hasn't done it yet. Once again, it is House Bill 3594. We'll go ahead and link that up down below if you guys want to geek out on it. We'll also link up all of Washington Gun Law's contact information. So if you have any other questions about this or anything else related to what's left of your Second Amendment rights, you'll know how to get a hold of us. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.